So good evening, everyone. I want to welcome you to the ADR section's effective negotiation and mediation techniques and strategies, views from both the attorney-negotiator and the mediator. We have two great speakers with us this evening, Lauren Tate and Phil Andersen. Lauren has more than 30 years of experience handling a wide variety of cases through trial, including personal injury, medical malpractice, premises liability, product liability, intentional tort, real property, and contract disputes. Lauren's mediation practice encompasses those same areas. Lauren is particularly skilled at maintaining controlled negotiations, managing expectations, and helping the parties reach settlements in emotionally charged cases. She is adept at connecting with the parties, engaging them in the process, and making sure that they are heard, feel empowered, and are committed to lasting resolution. With a strong belief in the power of mediation, Lauren brings to bear her extensive legal experience and emotional intelligence to create an atmosphere in which all of the necessary legal and non-legal issues are addressed and the cases are resolved. Phil Andersen has worked for more than 17 years as the managing attorney of State Farm Insurance Company in-house litigation department in Pleasanton. He has extensive litigation and trial experience defending policyholders in personal injury lawsuits and is an ABOTA member. Phil served as the president of the Contra Costa County Bar Association in 2017. He has volunteered as a mediator for the past 25 years and has mediated over 200 cases. Phil is currently working on his master's degree from St. Mary's College in marriage and family therapy. He also volunteers at the Contra Costa Crisis Center and works part-time as a drug and alcohol counselor. He also continues to serve as a mediator for the courts and recently opened his own mediation business, Phil M. Andersen Mediation. Phil earned both his undergraduate degree and his law degree from Brigham Young University. He is admitted to practice law in Hawaii and in California. And his wife, Candace Andersen, is also an attorney, and she currently serves on the Contra Costa County Board of Supervisors. Now, here's the most important fact about Phil. Phil and Candace have 6 children, and count them, 9 grandchildren.
Wow.
So
Nice.
here is, so I will turn it over to Phil, or I don't know who's going first.
I think Phil is going to start us off. Whoops, I'm not sure what I did. I've already shown
Okay.
there we are.
From the beginning.
All right.
Hello,
So-
everybody.
No, hit from the beginning.
From the beginning. Thank you. And there we go. All right. Phil, you are on.
Okay. All right. Well, thanks for attending, everybody. I'm happy to be here. I wanted to let you know that after retiring from 37 years of practicing law as an insurance defense attorney, I have some perspective from that side about what a participant in a mediation does and feels like. I feel like I still have an understanding of what the plaintiffs do too because of my mediation work. But I wanted to just let you know that to start off with, it's crucial that we as the litigators, the people that are attending the mediation, are ready to go. And one of the hardest things I feel is to put myself in the shoes of the plaintiff's attorney and the plaintiff. It's so hard because we are so engaged in what our case is all about. And it's very difficult to switch gears and think, how does the plaintiff feel? What does the plaintiff's attorney want to accomplish? Where are they going to start if they haven't already made a demand? Where would they end up? What are their best arguments? And if we can just make ourselves sit down at our desk and pull out a piece of paper and just start writing things like, where will they start? Where will I start? Where will they go next? Where will I go next? And who knows if any of that's right, but it's a nice experience to kind of force yourself to give it a try. And so what I try to do is I try to think, after I've thought through their case, which is, like I said, very hard, I think about my case and I think about, well, what is my most optimistic position, and kind of practice. How am I going to say this with a straight face when really I kind of know there's no way anybody's going to accept this? But there's some people in the world, and I always view this way, is that there are some juror members who would think of things and look through life through my lens in a very conservative way. And then there are other people at the other perspective. And so there's always going to be a range. So I start with my most optimistic on liability and damages and and really kind of comparative fault and where that comes from. And then I go ahead and try to attack head on in my mind, what am I going to do when they say, their case? For example, if it's a rear end accident case, and I should mention on the way home, I was rear ended, and I'm not just kidding. I actually was.
Oh, no.
Very minor for
Ironic.
me. But the 3 cars behind me were kind of messed up. But nevertheless, what I would try to do is try to think through what is the case about. If it's a rear end accident case, and if the special damages are $25,000, and the mostly chiropractic and some other stuff recovered within 6 months, but the interesting thing is the guy was a college student, and he claims that he had to miss a semester of college. Well, what are you going to do with that? And he's a really nice guy. What are you going to do with that? How am I going to deal with this really nice academic kind of guy? And what am I going to do to attack that head on? And what is it? Something he said in his depo that maybe was a little bit off, but I'll never accuse him of being dishonest or inaccurate. It's just, no, he's a wonderful guy, but here's some things that we can talk about. So anyway, that's what I try to do. It's pretty basic. We all try to do it, I'm sure, but just to reemphasize, there's nothing better than getting ready, even if it's going to take just an hour or so. And please, if you're on the insurance defense side or the plaintiff side, educate your client, because if you're sitting there and you're on a straight face and you're doing all the right things and they're like, their body language is just ruining it for you. And it hasn't that happened before. It's horrible. So please get in sync with each other so that you're ready to go. So that's my pitch on preparation. Thanks, Lauren.
Okay, so what Phil's essentially just outlined is the first point of my perspective. I will also say that I still handle cases predominantly on the defense side. So I have kind of both a mediator and negotiator viewpoint. But really, Phil has talked about setting his intention as the attorney-negotiator. What does he plan to accomplish? How does he plan to accomplish that? And of course, you have to be flexible because, as you know, although attorneys want to control everything, we don't really have a lot of control. So, but knowing what your game plan is allows you to be more flexible because you at least have a sense, your eye on the ball. So as a party, you really need to set your intention. As a mediator, you need to set your intention as well. And I think both of those things are accomplished by really taking the time Phil talked about to set that intention. But then also as a mediator, I always speak to parties ahead of time. And if your mediator doesn't reach out to you to speak to you individually about your case, how you see the mediation going, what your intention is, what your goal is, reach out to your mediator, because I think that can be one of the most important parts of the mediation. Do we do a joint session? Phil and I could do an entire presentation on the benefits of that or not, especially with Zoom. Zoom presents an unusual opportunity to kind of come to a meet and greet and not talk about the case, but talk about a child's artwork or a cat that's just run by. I just saw Marta's adorable cat, and of course we saw Malcolm's, and never underestimate the pets, ability of pets to bring you together and humanize. So, don't discount a joint session. I did an article that I think will be one of the handouts. Please keep in mind, number one, it was written for a plaintiff's bar journal. And number two, they requested that it be in the top 10 format. That would not have been my choice, but it talks a lot about the pre-mediation session, setting your intention as a party and a mediator. But the pre-mediation conference is very important for both. When I am in a mediation, many times, let's use an example of personal injury where I am meeting with the plaintiff and the plaintiff's attorney. I like to do a meet and greet, no attorney speaking, but a joint session just briefly. Here's who came together to resolve this case. Go to our rooms. And then let's say, for example, I'm meeting with the plaintiff and the plaintiff's counsel. Now, if the defendant is present and it's not simply an insurance adjuster, I will do the same for both. And if in fact both parties are not sophisticated mediation users, plaintiff rarely is, and if the defendant isn't, then I will do a lot of this in the joint session. But I really talk to people about what is a mediation. Many people arrive thinking it's like a deposition. They're afraid they're going to be questioned and put on the spot. I try to tell them immediately, that's not what this is. This is your mediation, right? We're going to make sure it's working for you. Talk to them about what we can accomplish and what we can't. We're not going to decide the facts. What they have control over. Talk to them about the fact that they have control over the decision now and what it means to hand that over to 12 people in a county that may be a jury of their peers and may not. To talk to them about the true importance of being able to listen to and understand the other side. And I often say that I may sound like I'm a cheerleader for them when I'm in the other room. But remember, when I come back in, don't shoot the messenger. I'll sound like a cheerleader for the other side because I'm going to present the information as strongly as I can so that you hear their best argument, so that you know what you're up against as you go forward. I don't expect you to agree with it. I'm sure we'll have your attorney will have a lot to say, and they won't agree with all of it, certainly, but very important to hear it. And I tell them that empowers you to be able to make a really good decision, an informed decision for yourself. So get them not only prepared to hear negative or bad news from the other side, but actually welcome it, because that gives you the information, the power you need to make your best decision. So I really try to make all of it very positive, even though they're going to hear some tough things. I try to set their expectations by letting them know, okay, fortunately, liability isn't disputed, but boy, we really have a lot to talk about in terms of causation. What injuries were caused by this accident? And also the issue of comparative fault. And that's maybe a difficult discussion. There'll be some things that are hard for you to hear, but again, so important. So I really try to make the tone sound very positive, so they're ready to hear the information by the time that it comes. Because if you don't do that, I feel like parties will just turn off and they won't be able to listen. They'll be taken aback. I tell them I won't tell them what I think their case is worth or what they should do. That would be arrogant of me to give them advice. It's not my job, and they don't need me. They're in good hands with their lawyer. But I will tell them what they need to decide to make their own best decision. I talk to them about, of course, risks and expense of going forward, et cetera. But another really important thing, I think, in terms of expectations is to tell people at the outset, we are talking about numbers because we don't have a choice. We can't go back in time. And we know that that would be your choice, and there's no amount of money we could give to have you want to go through this again. We know that. You also know what's true. And there's no question about that. You know how this felt, you know what you've been through, you know how you're still suffering, et cetera. But what matters when you hand it over to a jury is no longer, the outcome isn't determined by what you know to be true, but what can you prove to the jury is true. I think that's a really important step, because then people can understand, how is it possible when I know the truth in this case, I know what really happened and how I suffered. How is it possible that I won't do well at trial? Well, because you're not making that decision. It's a jury who hears specific evidence that, you know, judge may or may not allow in some of the evidence you think is strongest, et cetera. So really let them understand that the decision isn't a question of you're either telling the truth or you're not being truthful. That's not it. It's a question of what will a jury decide is true. And that takes a little bit of the emotional sting out of them making concessions and saying, okay, I see how a jury might decide this differently. So I really try to speak to them both very positively and honestly. And I always tell people, especially in a personal injury case, but even if it's a breakdown in a contract negotiation or an employment situation, I always tell people, you know, this is hard, and you should challenge your own lawyer and ask questions. You should challenge me and ask questions. Take the time that you need, and and really feel good about your decision, whether it's to settle or not, both today, tomorrow, and 5 years from now. So I really try to get them in the position where they know exactly what to expect. Nothing comes as a surprise except the information itself. But oh, I knew that was going to be hard. She told me. So really, I think that initial discussion with the parties is really very important. And we were going to take questions as we go, but I can't see the chat, and I apologize for my Tyrannosaurus Rex technology level of skill, but I don't know, Phil, if you can see it or if we have any.
Yeah, there's nothing yet
No
in
question.
the chat.
Okay,
Yeah.
okay. I also literally go through with people what the verdict form is going to look like, and in very short form, what are the questions the jury's going to answer. The components of the award, the special damages are pretty obvious, especially in an admitted liability case, but boy, that general damage, there's a range. And what you want to do is not go for your best or worst day. You want to get in that range of likely outcomes. And that's what you're aiming for here. I also tell people that successful mediation is sometimes knowing when to stop and when not to settle. Okay. When we need additional information, when you're not ready to make the decision for whatever reason. But I tell people too that we all stay mindful that although we're talking about numbers and we might get wrapped up in the number game of it, no one's going to lose sight of the fact that they are a person who has suffered, or they are a business person who's lost a good employee, or based on a misunderstanding, relationships have been strained, and we're not going to lose sight of that. So really try to talk to people in a very straightforward and optimistic but realistic way. All right, so I think Phil is going to start off talking about this very common thing. And although it's a thing that I think we often talk to young attorneys, there's usually more reaction, but I think everyone still struggles with this. So Phil, why don't you talk about that?
Right. Yeah, thanks. So I wanted to put in a little plug as part of this about that joint session thing. Tomorrow night at about 4:30, I'll be driving through the beautiful hills of Moraga on my way to St. Mary's College to a 4:30 class, which is on couples counseling. Now, this isn't divorce stuff. This is where couples are trying to stay together, and you're trying to convince them through therapy to get them to stay together. So you have a joint session. I mean, your client is the both of them, and they're sitting in the same room. One of the reasons I left the law early, I was going to wait until I was 68, I'm 65 now, was because I was sort of tired of the caustic nature of litigation. What I've learned in this couples counseling stuff is that if you can get people together and listen to each other, and you say something like, "What did you hear him say about that? How are you behind that 100% or not?" Or whatever the verbiage is. There's stuff that can happen psychologically, and I'm probably really old school when it comes to joint sessions because most people don't want them, especially plaintiffs' lawyers, because they feel like they're letting the cat out of the bag in a way. And honestly, from a selfish standpoint, I like a joint session as a defense lawyer because I learn a lot of stuff about the plaintiff's case.
That's why they don't like it.
I know, it's awful. But sometimes I learn stuff that's really powerful about their case, and so does my claim rep. And all of a sudden, the value gets changed. And sometimes I'm knocking on the door of the claim rep saying, "You got to put some more money on this one." And all of a sudden, they loosen up when they hear this wonderful college student that missed out on their semester. So, so anyway, I know it's hard to get people to agree to it, but I like Lauren said, at least some kind of an entryway. Now, if you're in the joint session and they happen to say they're out of the world demand for the first time you hear this, what's your reaction going to be? And what's interesting to me is that sometimes I try to tell the claim rep, you got to get ready for this, because if you hear it, you need to respond the right way. And the worst thing you could do with a really huge demand is to sort of sit there and kind of shake your head and like you're agreeing with, oh, that's not so, oh, I'm kind of surprised. That's not so bad, you know, and I want to tell them, no, look with horror and shock, or do something to make it look like this is, you know, the world just is coming to an end. But I never take them seriously personally. I understand both as a mediator and a negotiator that people do this thing called setting their anchors, and then they feel like they won the mediation because, boy, did you see how high they started, and now look what we got them to take. But that's just the way it goes. It shouldn't offend us. Just play the game. And I think if you prepared yourself well enough, and I kind of do this little V thing. So this is my hands here saying V-shaped concessions. Don't get thrown off of where you were going to start and go next a little bit less, and because of this huge demand. So that's my take on big demands. But what do you think, Lauren, about insulting? I'm offended actually when you call it an insulting offer, because I think they're always in good faith. But what's your take on it?
So I think the most important thing to do with stratospheric demands and the tempting, insulting offer is just to really talk about it. So I tell people, number one, neither a demand nor an offer has anything to do with the value of the case. And you know that. So don't be reactive, all right? The plaintiff may be insisting on this, and that attorney may need me to explain to the plaintiff how that's never likely to happen, all right? It's not realistic, and not only that, it's going to hurt their chance of settling the case, because the defense won't be inclined to put up money in a realistic way to get the case settled unless they think it's possible to do it. So as a mediator, I will often say to someone, what do you think the defense response will be to this number? You know, what are you trying to accomplish with this number? What signal do you want to send? All right. In terms of the insulting offer, I tell defense counsel, because there's one of two ways to respond to the stratospheric demand. It can be to say, gee, you know, I'd be inclined to offer $25,000 because, you know, this is legitimately a case with a value between 150 and 3, but they're at 2.5 million. I'd be inclined to start with a $25,000 or $50,000 demand, but they're so high, I just can't do that. I'm going to start with, you know, $5,000. All right. So again, you can do that, or you can say, you know what, I'm going to start where I intended to start anyway, before I knew what this demand was going to be. The important thing is, and it's very important to communicate with the mediator, what message do you want to send with it? And so it really doesn't matter. I've decided that in many, many instances, the number is not as important nearly as the message that goes with it. So if it's a very small quote, the plaintiff's going to be insulted by this initial offer. Well, it's in direct response. It's really, unfortunately, a reaction to your demand. Here's what I suggest. Why don't you make what you would consider to be a pretty significant move? Make in one move what you normally would have done in 2 or maybe even 3, and see what reaction you get from the defense. If you don't like the reaction, you can slam on the brakes. But what you may be doing is signaling to them, okay, we are here to resolve the case. We're going to be more realistic, all right? Versus taking an offer that's fairly generous in light of a stratospheric demand and say, you know, they were tempted to do something extremely minimal, but out of respect for the plaintiff and the process, they're just going to negotiate to the value of their case. So that's what they did, all right? And so please take it as that. Now, if you make a significant move, I think you're going to see them make similar moves that are very reasonable. If you won't come off this demand, I don't know that we're going to be here very long. So regardless of how you decide to approach it, and I don't think there's a right and a wrong, make sure you're very clear with your mediator what message you want communicated along with that demand or offer.
I'd like to say something about that, Lauren. What you've done is you've just spoken as someone who's someone who they can trust. And that is exactly what all the mediators on this call are wanting to be, the trusted neutral. And it works so well when you gain that trust. What if, though, you get this panel thrust at you from the court and you have no say in who your mediator is? And, you know, how much information do you give to the mediator when they start asking these really good questions that you've mentioned? And I think that's when I start getting kind of locked in lockdown mode. And I'd like, this mediator is not my friend. I'm not going to open up too much. And I'm going to almost play my game with them. So how you get to the point of trust is huge. I'm sure there's going to be a whole nother seminar on that, but the questions you've asked assume that you have that. And I think that's because you've had it and you've had that experience doing it.
Yeah. And that is true. You do need to pick a mediator that you trust and the right mediator for your style and your case. And again, that goes back to setting your intention at the beginning. So in terms of managing negotiations, so from my viewpoint as a mediator, I don't tell parties what I think they should do, but I've seen so many negotiations derailed because people send the wrong signal. So as a mediator and an attorney who's evaluated my own cases for 35 years, you know, I kind of have a sense of where I think the plaintiff is going to start, or where I think, you know, probably should start. You know, I have a sense of what I think the range I think the defense is going to pay. And once in a while, I will be very surprised, and the plaintiff will start with a number that I think is really too low for the case. And now am I imposing my own value a little bit? And I don't say that, gee, I don't think that's too low for the case. But what I'll say to them is, okay, yes, I will take them that number. Now, I just want to indicate, to me, this signals that you're headed to a range of kind of X and Y. And it's a relatively, you know, broad range, but it, you know, it might have, depending on what numbers we're talking about, it might have, you know, 10, 15, 20, $50,000 range. But that's the signal you're sending. So if that's the signal you want to send, okay, let me take that. And a lot of times people say, oh, no. We just don't want to start so high that they're not willing to, you know, we know they won't pay more than X, so we don't want to. And I tell them, well, okay, then think about what signal, and, you know, maybe you want to rethink that, et cetera. I have to be careful because I'm not trying to help one side. I'm not trying to get the plaintiff more money by doing that. But what happens is, if you want $20,000 for a case, and you start with a demand of 30, you're never going to get the defendant psychologically to get to $20,000, because by asking for 30, they're going to think you would have settled for, you know, 12.5 to 17.5 or something like that. And so I just don't want things to get derailed later down the road. I'll say the same to the defense. I'll say, okay, so, you know, that signals to me X, Y, you know, are we good with that? Oh, no, you know, okay. All right. Well, you know, whatever, you all decide. I'm just telling you what I think might be perceived by the other side. I often tell people, what message do you want to send? Not only in terms of your number, but what do you want to say to this plaintiff? All right. What are the things you want them to know? You know, very strict, no question about the specials, or, you know, very straightforward in deposition, very credible, very believable, you know, no issue about that. There are all kinds of and those are concessions in a way, but those are acknowledgments of strengths of someone's case. And if you send a number with that, you can then also say, and we also think X, Y, and Z. And so that can often be received. Again, regardless of the number, if the plaintiff starts at a number that I consider, for example, they do want to go ahead and do the $30,000, that's fine. And I tell them, what message would you like me to take with that? And what they might say is, look, we're starting at a very reasonable amount. We're not going to move very far from that, so they should expect small moves. Okay, perfect. You've cured the wrong signal with the appropriate message. I may do the same for the defense. Hey, out of respect for Mrs. So-and-so, this accident was through no fault of her own. For 6 months, she had her life ripped out from under her. We're not going to start at 10 or 15. We're going to offer, $50,000 right now, but please don't take that as that's something that, we're going to make like-kind moves. We really are starting much higher at move number 3 or 4 out of respect for, what's gone on. So really, again, it really is the messaging that goes with the number that is as important and sometimes more important depending on the situation. The other thing is we all have situations where an attorney or even a party will say, do you think they'd take X? Okay, well, oftentimes, and I think it's a real ethical dilemma, if I as a mediator know already they'll pay they'll take less than X, or the defense will pay more, do you think they'll pay Y? I know they'll pay more than that. You have to be very careful because you're in a position where you could favor one side or the other. So I will often say, you can test them anywhere you'd like. Okay. And so then I put it on them to decide, well, we want 30. Okay, maybe we'll say, gee, we might be talked into 40. Okay, but I often will tell people, you can test people, you can push against that, see what happens. So again, I think it's really important to have a mediator, A, as Phil points out, that you can trust, and B, really have your signals clear between your client and also with your mediator. By the way, as a mediator, I always ask the client in front of the attorney, are you okay with this move? And the reason I do that is because as a mediator, we can get so caught up in Phil. Okay, here's the response. I think you should do X. Lauren, I think that's crazy. Da, da, da. And Phil and I could get so caught up in what Phil's next move should be. Okay. And the plaintiff's kind of sitting there like, my case, excuse me, so a lot of times they'll speak privately to the attorney. That's fine. I come back in the room and the attorney will say, I want to do X. Okay. And I always turn to the plaintiff and say, are you okay with this move? And I can't tell you the number of times they say, well, and I say, okay, ask me any questions, ask your attorney questions. You may speak privately. What do you need to do to be okay? Because if you're not, let's not do it. And usually they just need it a little more. So I think that is the best way. Be very intentional, be careful about your signals, appropriate messaging with your client and with the mediator, and then understand about testing. So that's my perspective. Phil, you're going to talk about your beloved B.
Oh, my beloved tapering. I just wanted to mention that what you just said, you can test the extremes of your ethics as a mediator if you have an unrepresented litigant. And that is really tough, isn't it? When you're trying to not help them too much, but that's when you really have to kind of check yourself. But I think you said some beautiful language of how to do it and sort of thread that ethical needle to make sure it's fair to everybody. So on the tapering thing, so like I said, I got this little V going, right? So I always feel like the next offer that I'm going to make should be a little bit less than the one that I made last time. So it tapers down and it kind of ends up, and you can kind of read it after about 3 moves. The plaintiff side can see where you're going to end up in a way. And that's good because you sort of want to signal something that may not be your actual number. Ha ha, I fooled everybody. Well, usually you can't fool people that well, but there is something psychologically powerful to being consistent and to not jump around too much and always sort of taper down to where each one is a little bit less than the one you get. Or if you're a plaintiff lawyer, go up a little bit more, but not more than the last time you went up. Now, all that said, I've had claim reps who completely disagree with that, and they'll go in and they'll just blow it all up and they'll make my taper thing look like a jigsaw puzzle. And I just think, what the heck did you just do? And the mediation turned out perfect. And we settled the case. And I just think, oh my gosh, here I thought I knew everything, how you're supposed to do it. And they did it the different way and it worked. So, take it for what it's worth. but I think it does have some psychological benefit to taper down at a number that maybe is a little bit lower than the number that maybe you have enough money for. And then if you have to, you spend that extra money at the end. Anyway, that's just my thoughts on tapering. Lauren?
So I think of the V as, of course, that's the goal. And I always tell the plaintiff, you're starting here, they're starting there, okay? And I don't say we work toward the middle, but I say we work toward the range where this case can settle. I look at the V as more but your ultimate goal is to get to the bottom. I love the carrot and the stick. I love the plaintiff's attorney who will reward the good defense attorney because they made a reasonable offer. But oops, there comes now their insulting move. Yeah, we jammed on the brakes. Come up a little more. Oh, we're going to make a significant move. Took advantage of it. We're slowing down. So I like some flexibility and the kind of carrot and stick, but I will say, you know, the defense just made a significant move, all right, and has kind of broken our logjam. I think you need to reward them. We're going in the right direction, so reward them, reward that move. And if you don't like the response, then you can put on the brakes a bit, all right, send a different message. So I really, again, think ultimately this is the goal. And you taper not only with numbers, but with information. I think there's difficult information plaintiff's not going to hear when you're still at the top of the V. As you discuss the case more and more money is being offered, now I think they're ready to hear X. And as a mediator, I will often say to the defense, I think one of your strongest points is X. I also think we need to be strategic about when we talk to the other side about that, because we don't want it to hijack the negotiations. It needs to be at a point where, you know, they're far enough down the road that it's going to keep moving in the right direction. So both with arguments or positions as well as money, I don't think it's quite as nice and lineal. And I have seen people push back against the just incremental by saying, look, I'm not going to keep coming down if you're going to go up $1,500 every, you know. So again, you just need to be thoughtful and flexible, and keep an eye on messaging about that. So I'm going to talk a little bit about bracketing, and everyone thinks they know what brackets are. And I will tell you, I did too. You use them at the end. You don't use them very often. Some people will just say, oh, I hate brackets, and just shut down. And I say, I'm making you listen to my little bracket spiel. All right. And here's why. I had one of the top plaintiff's attorneys in the state, if not the country, who handled the case for my daughter. And I witnessed during a mediation with a retired judge, I witnessed him use brackets. And I learned more in that hour and a half, which was the second most stressful hour and a half of my life, than I've learned in 30 hours of mediation training on effective bracketing. And so I think it's powerful enough, and I use it in almost every mediation, whereas in the last 30 years, I probably used it 10 times total. All right. But now I suggest it almost all the time. I suggest it early because you have to have enough room to move to do effective bracketing. And I suggest it even in cases that settle for less than $20,000, believe it or not. Okay. Here's what I love about brackets. If you do a bracket, and brackets, just in case people don't know, very simply, a bracket is, albeit, you know, the plaintiff's attorney comes in at $500,000 and the defense is offering $25,000. Okay, the plaintiff says, look, I'll be at 300 if you'll be at 100. Okay, I'm not really at 3, I'm still at 5, but I would be at 3 if you'd go from 25 to 100. Okay, add those numbers up, 3 and 1, that's $200,000 is your midpoint. Okay, that's what you would be saying. So now sometimes people use brackets and say, well, I'm suggesting the midpoint. No, no, no. My rule of bracketing, if you use them in my mediation, is you have to mean your midpoint. So plaintiff, you have just announced you would take $200 right now to settle your case. Defendant, you've just announced you'd pay 100. Now, does that put you in a bad position? If you're a plaintiff's attorney and you would take the 200, then no. Why not say it? All right, important second rule, don't ever do your best bracket first. So if you want 200, then you're going to bracket 250 or 225. Leave yourself wiggle room, and we never know how much wiggle room, but, and the great thing about brackets, don't ever expect the other side to accept a bracket. They don't. I've never seen it happen, never. Assume they're not going to, but what you want to do is convey the possibility of what can happen. As a defense attorney, it's very powerful because now a plaintiff who's scared, who's afraid he or she's going to be taken advantage of, you know, they heard 25, now they hear a six-figure number. Wow, this is real money. Okay, this is a whole different ballgame. So it shows what's possible. And let's say you have a midpoint, the defense has set a midpoint of 200, or the plaintiff has, and the defense says no, but gee, you know, if you were at, we'd be at 50 if you were at 75. All right. Now, why do I do a bracket that, okay, we'd be at 50 if you were at 100. Okay, now I can divide that in half at 75. Now the thing that makes brackets magical creatures is now you have two midpoints. The plaintiff's midpoint is 200 and the defense's midpoint is 75. Add those two numbers together and divide them by 2. And that is the range in which this case can settle. It doesn't mean exactly the midpoint, but it is almost always within, variant of, a small percentage where that case is going to settle. I think with brackets, you have to be flexible. It rarely makes sense to go back to numbers once you've started to do brackets. But once you start, you've got a midpoint here, a midpoint here, you keep working. And then typically what happens is a series of last best finals, and not last best final, I am leaving the room, but our midpoint's X, but we would take X if you would pay it. Yeah, no, we'll do this midpoint, we'll pay Y. And then it really sets things up nicely for either the parties just resolving it again with making small moves toward the place where it's going to settle, or for a mediator proposal. And I'm not as simplistic as the midpoint of the two initial midpoints, but you really do get a sense of really what the plaintiff is willing to take and really what the defense is willing to pay. And it just saves so much time. And I had one mediation where the claims person was just, I don't like brackets, I've never seen them used, etc. And about 2 hours later, I said to him, look where you got. Do you realize you could have gotten there in a bracket in about 2.5 minutes? And he said, how? I said, because this would have happened, then this, then this. And he said, oh, okay. So don't shy away from them either because you don't understand them or because you haven't used them before successfully, but you have to use a mediator who knows how to use them. So I think they're very effective. Do not shy away from them. Just keep them in mind. I had a bracket of 13.5 if you were at 17.5 or something the other day. And I know that sounds silly, but the parties were really having trouble moving, getting any movement. So it worked. It does typically work really well with a stratospheric offer and the insulting demand and the insulting offer scenario. When you've gone back and people just aren't willing, I'm not going to show you mine if you don't show me yours. That's what brackets do. Show me yours, I'll show you mine, kind of, and let's get it done. So I want to say one more thing about mediator proposals. I think they are very effective. And I always explain to the parties, I like to do it in a joint session so they know I'm saying the same thing to both sides. Most people don't want to get into a joint session toward the end. So I tell people this is not the number I want to see you get or the number I want to see you pay. It's not the number I think is the value of the case. It is a number that I think plaintiff might be willing to take, but isn't so much the defense still may be willing to pay it. Obviously, most of you know that's what a mediator proposal is. I think it's an important number because and again, it depends on credibility. If you have credibility with the defense attorney and the claims person or the defendant, then the fact that you have put the number out there makes it less difficult to say, okay, let's be done, let's pay it. And for the plaintiff, I think plaintiffs really, I mean, most people have good relationships with their attorneys, but I think people are still a little bit worried. This isn't what they do for a living. They're feeling a little uncomfortable. And if you've made a connection with the plaintiff and they feel like you've been speaking to them honestly and they can trust you, then they're more likely to trust that if you thought the defense would pay a little more, you probably would have done it for a little more. This really is your sense of where this case can settle. And so I think it has more credibility, but you also have to be very careful with it because it is an opportunity to favor one side versus another. And so it's something that I think long and hard about. And people always say, well, yeah, you can do a mediator proposal, but what would it be for? Well, then it's really not a mediator proposal, is it? It's a number that you're going to say, oh yeah, no, we don't want one then. Okay, no, that's not how it works. But I sometimes say, I don't know, I'm really struggling. I'm going to have to think about it for a bit because I'm really struggling because I've listened to you both and so that's my
just a little add-on on that mediator's proposal is that I've always appreciated it when the mediator gives me a chance to opt in to the concept of the proposal. And I've had a few mediators, again, the court appointed that I never agreed to, who sort of almost vindictively say, well, then I'm going to, do a proposal. It's like, no, wait, I'm not, I don't really want you to do that. And so I think we need to have the buy-in. And that's what you were talking about, I think.
I think, I don't know, and I know who might know, and that would be Malcolm Shear, because Malcolm, you know so much about so many things, mediation, but I personally would
You're
not.
being too kind to me, Lauren, but
No,
I use bracketing actually quite a bit.
You?
I do. I
Yeah.
seldom use mediators' proposals, but I use bracketing quite a bit because I think I understand it, but I explain to folks what I'm doing first.
Okay. I think it's unethical, and I could be wrong, so someone correct me if you don't think so. I personally wouldn't do a mediator proposal unless both people ask me to, because sometimes people are more honest in a mediation than they think they should be because they trust the mediator and they think it'll be effective. And that can be taken advantage of to some extent with a mediator proposal. So there are cases in which I will say, I don't really feel like, at this point, it would feel like making an arbitration award, and I don't feel like I can do it. So I kind of really am pretty thoughtful about those. I will tell you this one funny story. I literally had a case where the defendant was willing to pay 75 and the plaintiff's 998 was 81. Really? I honestly, and I finally, I just said, I went back and forth. I spent so much time, I don't bill for follow-up, and I had spent, and I finally sent, no one asked for a mediated proposal. The defense was adamant they would not pay more, plaintiff not taking less, no one asked for one. And I finally said, and I'm quoting, counsel, over my dead, cold, and decaying body, will I let this case not settle? I don't care if you want it or not. The mediator proposal is for $78,000. Settle this case. And they did. And they laughed because they realized, of course, I was being funny, kind of, but was I? So it worked, but that was probably the most dramatic example of a mediator proposal I've done. And I actually say that a lot in mediation. Over my cold, dead body, will this case not settle at this point? We are too close. All right, we need to figure out how to go forward. So, all right, so, just one, it's like the Columbo, mediation Columbo guy. Oh, just one more thing. So Phil, I think you're going to talk about this.
Just sneaks up on you, and you've got all this emotional energy and you're just so excited because the case is going to settle. You think for the number that you thought, and all of a sudden we could do this if you would just pay for the mediator fee, or make sure I get that confidentiality agreement, or that that check within 5 days, or that all liens, I'll take care of them. Don't worry about it. It's just disaster when it comes up at the end. And so the question I guess we all have for Lauren is, how do you prevent this, what we call nibbling at the very end, and deal with that?
Well, there are certain cases like a medical malpractice case. There are other types of cases where you just know that the defense is going to want a confidentiality clause. There are certain types of cases where those are either not legal or the plaintiff is never going to agree to one. And you just need to know that up front. And if you don't, that's again the purpose of the joint session. I mean, the pre-mediation call to plaintiff's counsel. Is this just about money? What's going on? What are you going to need? What does settlement look like to you? Don't tell me the amount because, necessarily, because we're not there, but well, my client really wants an apology. And that's you could do 5 hours on apology. A lot of ways to get an apology. My favorite one is to say to the plaintiff, you will never get an apology from this person. And if you did, you would want to punch their face because it would not be a genuine apology. They're not capable of giving you one. I will tell you this, by them conceding and consenting to settlement, they are essentially admitting that they really made a mistake. And I guarantee you the fact that you brought this lawsuit and prosecuted it and had the courage to see it to this point, you've gotten your apology. Essentially, you've gotten an admission that I will not do this again. I won't treat a patient like this again without, I will not go through this course of treatment and action without really thinking about it. You've made a difference. Now that's not them telling you I'm sorry, but you try to cobble together some real non-monetary benefit. And I'm not just blowing smoke. I think that can be really true. Plaintiff needs to know someone listened to him. Well, your message came through loud and clear because this doctor hasn't settled a case in 36 years of practice and he's doing it now. So there are ways you can really kind of cobble that together. So if you know ahead of time, then you can listen to what both sides are saying and be looking for your way to give the plaintiff something like that might allow them to put that part of it away and then go on and resolve the case. The confidentiality clause, always a thing. And I just always tell plaintiffs' attorneys, stop it. If you settle a case, you're buying your piece. You should be entitled to just have it be done with, not have the PR, the headache, etc. Stop it. And sometimes they listen to me and sometimes they don't. No, I want more money for it. Well, you're not going to get it, etc. So in any event, it's more, again, don't wait to the end. Don't make it, oh, just one more thing. Make it, I need, blah, 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 and early on. So I never wait until we're very close. I always will say, is there anything else you need? There's one firm that always asks for mediation fees. Well, I'm not going to remind them of that. That's not my job. It wouldn't be appropriate, but I know. So I say, is there anything else? Oh yeah, mediation fees. Okay, oh yeah, this, oh yeah, that. And so just know ahead of time and tell your mediator and anticipate it. As a defendant, if you need confidentiality, tell the mediator up front, we're going to need this. And most attorneys do. So I think that's it in terms of that. I want to say, because we have a few more minutes, if you don't mind, I would like to talk a little bit about Zoom. So when we first started doing Zoom, I am a very people-y person. I have been known to hug sobbing plaintiffs in a mediation, and then 10 minutes later, I'm explaining to them why the defense isn't going to pay any money, And I always tell the defendant, my jacket's wet because the plaintiff was crying on my lapel. So to the extent you don't think that was a neutral action, let me just tell you, she's now in a place where she can hear what you have to say. So are you okay with it? Yeah, okay, fine. But I thought mediating by Zoom is never going to work. This is crazy. I just have too much in terms of my facial gestures, my body language. Never going to be able to connect with the plaintiff. This is horrible. And I wrote an article ranting against it. Well, about 6 months ago, I wrote an article called Eating Crow because I was so surprised by the benefits of Zoom. I do miss people. I wish we were all together, but I will tell you that I am amazed at the difference. Plaintiffs are in, and I do a lot of personal injury, you can tell, but defense attorneys, this isn't their first mediation. Claims people are bored by the process. They want to get their work done. All right. So for one thing, we're getting claims people from Arizona, from Minnesota, from Colorado, and they're with us. We can hear and see them. They're listening to everything that's said. I think that's awesome. And that's what settles cases. And plaintiffs are so comfortable in their homes. They have a pet going by. I had a woman that held a, brand new baby the whole time. And it was very comforting to her. It wasn't distracting. I kept telling her, pull your screen down because I want to see the baby, not you. So maybe it was distracting for me, but there are really opportunities. Like I said in the joint session, there are ways to kind of humanize people and connect. But then just as the mediator with the attorney, and it's not just the plaintiff, it can be the claims person. Here comes, the cat or the dog, or I'll say, excuse me, is someone else wanting to say something? And it'll be a bark. And they say, oh, that's, so-and-so. And they hold them up. And, 5 minutes ago, they were gruff. They weren't going to give me any more money. And now they're holding up a little dog with bows in the hair, it's like, oh, this is Maya. And, suddenly there's a real shift. Now, do I say that I manipulate people with their pets? No, because I genuinely am very interested in them and engaged. I have my dog here. My dog's with me at every mediation, but it humanizes people and it really breaks I don't want to say a toxic thing, but there's kind of a snarky kind of the sort of we're in a war, we're on different sides. There's really something about pets and people being comfortable in their own environments that really breaks through somehow. And I think it is really remarkable how it's working. And I in my article, I wrote that when the pets come out, the case is going to settle. It has never failed yet. And I think that's why. It has nothing to do with the animals, but it really does remind us, this has been really hard and we've all gotten through it together. We all struggle in different ways. We're trying to find childcare and, a place where we don't look completely ridiculous in the light like I do right now in your Zoom, setting. And we're struggling with technology. And it just really kind of reminds people, I think, in a really nice way, where you can be, self-deprecating, you can be sympathetic, and in ways that has nothing to do about the case that really brings people together. So I really do think Zoom is here to stay. I'm happy to go back in person, but boy, I don't think we've suffered at all. So I don't know about your perspective on that, Phil, or anyone else. I'd love to hear someone else speak.
Yeah, thanks, Lauren. And I think we just had a comment from Peter Mencken, just wanting to know where to find your article. But I think it's a great time to sort of open it up for people. We've got another maybe 5 or 10 minutes just to everybody share with each other your best practices.
Let me, you want the Eating Crow article? Is that the one that you want?
Yeah.
Okay, yeah, I'll put it in the chat if I can find it. So someone else speak, please, while I look for that.
One of the things I found with Zoom that I think I didn't realize it until I realized that most Americans spend probably 2/3 of their life watching TV. And by doing that, they tend to focus better on a TV screen than they do when they're with a group of people. So one of the things that I like about Zoom is when I'm talking to them, I can see their eyes. I think they're focusing definitely on what I'm saying, and I was surprised, like you, Lauren. I thought it was going to be, oh, this is going to be crappy, and we're never going to be able to develop any sort of relationship with these people. We aren't going to be able to schmooze the way we did when we're in the mediation rooms. And the exact opposite has been true. They are focused on what's going on. They're focused on what's being said. They don't seem to be as distracted as I found them. Maybe the something that I did distracted them, but they don't seem to be as distracted as I used to find them when we were in mediation rooms, where they could look out the window. That there's pictures on the wall. There may be books on the shelves and things like that. The only troublesome thing is when I can see them looking down and I know they're playing with their phones, there's no way to be like the grandmarm teacher saying, "Put your phones away." But you do have to say that. But I just think it is an improvement in a lot of ways over face to face.
I do say, am I boring you? Are you texting someone? What are you saying?
Oh, I thought you were going to.
And I do it kind of in a funny way, but I'm.
Are you saying something there that we could share with the others?
Exactly.
I always say no multitasking allowed when I see people playing with their phones or lawyers turning away and it's very clear that they're doing something else. I say no multitasking allowed. The only thing I don't like about Zoom is I always used to take some food to the mediation, even if it was a cake. And if there was a joint session, I would put the cake in. I would ask somebody to cut the cake. Would you do us the honors? Something like that, because I liked that, and I'm not able to do that.
That's a good point, Malcolm. I don't know if everyone remembers Charlotte Venner, one of my all-time favorite mediators, and one of my second all-time favorite mediators is her partner, Fred Carr. And Charlotte always brought some yummy baked good.
Yeah.
And it really, and I know that Harris Weinberg always felt that you break bread together and therefore you're coming together, very symbolic. There's something to be said for that.
Harris always used to say people who break bread with one another will generally work out their differences. And a lot of the training I did was with Harris, great guy, and I kind of like doing the same.
Yeah. Let's see. And I'm sending you my article because, again, my technological prowess doesn't allow me to put it in the chat. It's so sad, but see, I told you I'm a people person, not a.
That's
Fred,
okay.
oh
Everybody
God.
will get it, and I want to see it too. So.
Okay, Fred is with us, so I didn't mean to do a shameless plug for Fred. But Fred, now you know it's an honest, shameless plug, so. Anyway,
Did I hear Hungarian cake?
Oh, no, there you go.
I knew that it was, Lauren.
Okay, all right.
Where is this Hungarian cake coming from?
When's it coming
Yeah.
out? Could we?
I don't,
on the
Charlotte
break?
had a bakery in Marin County. Fred may know where that is, but
Yeah, it was Sweet Things over in Tiburon.
What?
Ooh.
Sweet Things in
So now
Tiburon.
there is
Tiburon.
somebody cooking Hungarian food and that's not me.
Fred, do you bring baked goods to your mediation?
I continued Charlotte's practice. I thought it made a lot of sense, like Malcolm had pointed out and others. It's, I think it's a icebreaker, if nothing else. And it also serves a very functional purpose. When people's blood sugar starts going low, you can't think straight. They can't do the math. They can't do the brackets. So pumping up the blood sugar actually helps too. So yeah, I continued the practice and I got the Hungarian coffee cakes at the same place that Charlotte did.
Yeah.
I used to do something really shameless. I would get, when the people were arriving, I would say to the parties, can I just talk with the lawyers outside for a second? And then I leave the parties in the main conference room with a cake.
So they get the best slices. Yeah.
Yeah. And the parties are together for the first time, perhaps in 10 months.
Yeah. One of the things that I really do with mediation, and sometimes I think people will think, oh, am I being too casual? Or I take mediation very seriously. It is a legal proceeding. It has very strict, important rules, purposes, goals, etc. But it's also a group of people in conflict. And, I've had mediations with a vice president from some big corporation, flies out from Chicago, and he ends up, he's tearful at some point because he's really sad about the relationship with the employee that's really broken down and he wants it back. So, I always try to look for the humanity in the conflict, but also I think it never hurts to, whether it's a little bit of humor, of course, not at, appropriate, not at anyone's expense, mostly at my own or something, or but to really remind people we are human beings working through conflict. This is hard. These are crippling decisions for people. Just think if you live out in you know, some rural community, getting dressed in something you think is appropriate, driving, getting to BART. Oh my God, taking BART, that's a huge deal for some people. Going into a law office, elevator, you know, it can physically be, it's terrifying to some people. So by the time they get to the office, they're just a wreck and they're not comfortable, they're not listening, you know, they can't listen. You know, you can just strip that away and let people feel comfortable and et cetera. But whether it's in person or by Zoom, I just think there's a lot more opportunity to just remind people of our humanity and what we're trying to accomplish and what people have been through and are going through. And, you know, I tell plaintiffs all the time, you know, the claims people have a really difficult job. They have so many files and they really do try to take time and put a lot of respect and thought into your case. They don't just, you know, spew it out of a computer, you know, and I never will allow a defendant, because it's my rules. I never will let them do a $33,012.85. No, you round up or you round down, because otherwise it sounds like what it is, something that just came out of a, you know, algorithm. No. All right. Because I've just spent the 5 minutes telling the plaintiff how thoughtful and respectful you are. No, you know, different number, please, lower or higher, but I'm not doing that.
Could I just say one last thing about humanity? I told the group that I was in a car accident about 2 hours ago. On my way home to this session, I was rear-ended in a 4-car accident, and I was the first car, and there were 3 cars behind me. So I go back to the car that caused it, and her whole hood is all crushed up. She can't get out of the car. She can't start the car. I'm trying to share information with her. She doesn't look too injured, but the airbag is out. And she says, I am so sorry that I caused this accident. I am so sorry. And I'm so glad I have this insurance. And, you know, it's not the former company that I worked for, but it's a good insurance company. She said, I'm so glad. And I know that they'll take care of this and they'll be in touch with you. And I just thought, you know what? That's humanity. And then there's another guy walking around going, oh, my neck, oh, my neck. It's like, yeah, maybe, maybe not. But anyway, humanity is the reason that we get into this business. It keeps us going. I think as mediators, we can do so much to bring that out. So thank you, everybody. And thank you, Lauren, for wonderful program.
Great program, as usual. Terrific.
Yes, thank you. Thank you, Lauren, and thank you, Phil. And I'll thank Nathan Shig and Absentia for getting everybody together and getting this going. He's the ADR section leader. Also, I should put a plug in for the April roundtable that he's planning. A couple of the things you guys brought up today, especially the bracketing, right? And all of that, the discussion, the few things he's going to talk about during the roundtable. So just make a quick plug for that. And hope the next time we do this, it'll be in person.
Me too.
And,
thanks everyone for coming.
Yeah. Thank you, everybody. Have a great evening.
You too.
Good night.
Good night.
Thank you all, and thank you, Ann, for getting me jumped in there.
Oh, no problem. Sorry about I came
No
you a little late.
I appreciate it. Thanks.
I was busy talking to everybody here.
Well, last minute registration. I didn't mean to drop it on you, but thank you for doing that.
No worries. You know, it's interesting because I'm usually all over my email. Like I keep one eye on my email, but I can't answer my phone or get a voicemail because the sound comes through my computer. So I'm like, well, I better wait. I can do it on my phone or so.
All's well that ends well.
Perfect. Okay. Thank you.
Take care.
Oh.
There goes.
Lauren, you're all good?
Yes, thanks so much, Ann.
I think I have all your stuff.
Okay. I thought you needed something to hand out for people to get MCLE, but if you don't, no problem.
No, I do. I have that article, but then also, can I send your PowerPoint out?
Oh, yeah.
Yeah, and Phil sent a couple articles too, so I'll put that all together and send it out.
Perfect. Thanks so much for doing this.
Thank you. You guys are great. Really appreciate it.
Take care.
Bye.